Hello and welcome to another edition of Coffee Talk with immigration attorney Brian D. Lerner. In this particular episode we are talking about the various appeals that can go forward in immigration law, and there are a lot of them. When you're fighting in immigration law, many cases, as a matter of fact most cases, unless they're the essentially basic run-of-the-mill, no problem, no issue type case, you're fighting an uphill battle. That's the reality. And in order to eventually win, and in order to have a chance at winning, many times you have to fight a few battles to win the war. And so, you have to go into the immigration arena per se with the expectation that you may not win the first round, and that's okay as long as you keep fighting. I've had many cases that I've had to go 3, sometimes 4 levels up before I'm able to secure a win. But the only problem with trying to, for example, go to that top level first is it would be thrown out, because they would say you must exhaust your administrative remedies. So let me give you a typical scenario. Somebody gets put into removal proceedings, okay, into deportation proceedings, and let's say they're applying for asylum, and let's say that the judge doesn't believe them and makes a ruling that they're not credible, okay, and denies the asylum case. From there, what happens is you have 30 days in which to appeal to the Board of Immigration Appeals. Now, keep in mind what we're talking about now is still all under the ambit of administrative law, okay? No actual judiciary or federal judges yet are involved in the picture. You have to go through the statutory procedures to appeal under administrative law before you do anything else. So now let's say you appeal to the BIA, you do the notice of appeal, and then you'll get a date which the opening brief is due, and then the opposing side will reply to that, and then will oppose that basically, and then you'll have 14 days after that in which to submit a reply brief, and then you can designate whether you want to orally argue at the Board of Immigration Appeals or not. And if so, and if they choose, you go there and basically the attorney would go there and then orally argue the case. Now, once it's at the Board of Immigration Appeals, it does take 6 months to a year, give or take, to get a decision on the matter. And let's say that they deny it. Okay, so now you have a denial from the immigration court and a denial from the Board of Immigration Appeals. So now, for the first time, you can actually jump into the federal court system, where it's not just immigration law, where these justices were appointed by the President of the United States and confirmed by the Senate, and you do what's called a petition for review. So the petition for review is done at the Circuit Court of Appeal in the jurisdiction where you live. So there's about 11 circuit courts jurisdictions across the United States. You can basically slice down the United States, start in the New York area, and that's First Circuit. Go all the way over to California, Hawaii, that's the Ninth Circuit, and depending where you are, will depend on what circuit you will file in. And then again, you have 30 days to do that. And once you file the petition for review, there's no longer an automatic stay of deportation. So, you'll get the motion to stay the deportation filed as well. And then what will happen is the circuit court may decide that they want to have you orally argue as well. So they'll go and give a decision based upon your oral argument and all the briefs. And at the Circuit Court of Appeal, they may, there's really 3 things that may happen. They may flat out deny everything. They may flat out approve everything, or they will approve and deny some and then remand some back to the Board of Immigration Appeals. So that's how that works, and depending what they do will depend on your next step. Now let's say that they deny everything. Okay, let's say the circuit court denies everything. Well, from there you can do what's called a petition for rehearing en banc. Okay, and that is where you essentially say to the circuit court judges, all of them, you say, look, you think that the three judges, that's who's on the panel who made the decision against you, are wrong for all these various reasons, and you would like the entire panel of judges in that particular circuit to hear the case, and so you can file a petition for rehearing en banc. Now let's just say they deny it. Okay, you then can do what's called a writ of certiorari to the U.S. Supreme Court. So you see, we've gotten from the immigration judge or the immigration court level all the way to the U.S. Supreme Court in a relatively expedited manner. It may not seem expedited for the person who's doing it, but compared to other areas of law, to get up to the U.S. Supreme Court is really quite shortened experience. Not to say it's easy, but those are the basics from the immigration court. Now, the thing about appeals in immigration law is it will depend on what it is you're applying for, who it is that denied it, and where you go from there. So for example, another example, let's say that you filed for an extraordinary ability alien petition, okay? Or better yet, let's just say you filed for just a regular I-130 for a family petition, yet they don't believe that, for example, the marriage is legitimate, or whatever reason they give. And then that would be the USCIS. Well, from there, you could appeal that to the AAU, okay, the Administrative Appeals Office or unit. And if the AAU, let's say, denies it, that takes 1 to 2 years. If they deny it, that's still under administrative law. You could actually then go to federal court, U.S. District Court. That would be different than the circuit courts of appeal. So you'd go to the U.S. District Courts in your jurisdiction and file there for the particular relief you think you're entitled. And then if the U.S. District Court denies the case, then you would do a direct appeal up to the circuit courts of appeal from there. Okay, that would be different than the petition for review to the circuit courts of appeal directly from the BIA. So you can see there's some interesting twists that happen with the appeal. Now, just to give some more examples, let's say you applied for naturalization and you had your interview, and more than 120 days has passed and they haven't made any decision. Well, from there, you could do naturalization action right in U.S. District Court to have the district judge rule directly on the naturalization matter. Okay, there used to be all kinds of habeas corpus petitions you could do in U.S. District Court, but the majority of that was taken out by the Immigration Act of 1996. Not to say it still can't be done in some respects. Okay, but there are all kinds. I've given just a few, of the types of appeals. I mean, let's say you're filing for a perm, what used to be called labor certification, and they deny it. Well, you can appeal that up to BALCA, the Board of Alien Labor Certification Appeals. So there's all kinds of paths that need to be taken, and actually one of the more difficult parts of the appellate process of immigration law is knowing where to appeal it, when to appeal it, and how. I mean, if you're 30 seconds late with the appeal, then it's garbage. They're going to throw it back and they're going to say, sorry, but we don't need to hear this. So you want to make sure that when it does go up on appeal, that it's taking the right path, that it has the necessary elements, and that it's done timely. I can tell you when I'm in immigration court, I'm always thinking in the back of my mind, well, if this thing goes up on appeal, I need to make the record, okay? I need to have appealable issues. So, for example, if somebody, the other side is trying to bring in evidence that's irrelevant or trying to do something that I don't think is legitimate, I have to object. And I have to make the objection on the record so that if it goes up on appeal, that it will be listed in the record, it will have the evidence and so forth. I can remember there was one case in immigration court where we were applying for various forms of relief, and I remember it was about 15 of 12, and the immigration judge kept looking at the clock. She kept looking and looking, and I was kind of wondering why does she keep looking at the clock? You know, if it comes lunchtime, just continue it, and we'll, you know, go continue after lunch. Well, the witnesses she cut short. My objection she cut short. She cut everything short, and the reason she did it was so she could go to lunch. I was flabbergasted that a U.S. immigration judge would put the balance of someone's path of their life as to whether they can stay in the United States or go, based upon the fact that she wanted to go to lunch and not continue the case until after and allow a full evidentiary hearing on the evidence. Well, needless to say, we appealed that to the Board of Immigration Appeals, and we lost. And then we appealed it to the Ninth Circuit Court of Appeals. We did a petition for review, and sure enough, they saw, based upon the record, based upon my statements, because I did object at the time of the hearing. I didn't quite say, Your Honor, I know you're hungry and want to go to lunch, and this man's life is in your hands here, but I did make it clear that she was cutting it short, that she wasn't permitting me to do my objections, she wasn't allowing the explanation of the testimony from the witness, and sure enough, it was found to be a due process error by the judge, and it was sent back. And I have to tell you, it was quite pleasurable for me to go back into the immigration court after it was remanded back from the Ninth Circuit Court of Appeal, so that she could actually sit there and hear the evidence and make sure that the record was fully expanded upon. It turns out we ultimately won the case, but we did have to go that whole route in order to do it, and sometimes the unfairness of the actions make it so that you have to you know, do the appeal. And it's good to have appeals, because if the law's unfair, or if you know, the situation's unfair, you go up and you appeal it. And to bring that point, you know, the immigration attorneys do not, you know, we don't actually make law. You know, it's the Congress that makes law and so forth. But when they come out with these laws that are so anti-immigrant, and it's unfair, the laws are signed, you know, into law by the president and so forth, but the ramifications of those laws, many of them, are not usually seen right then and there. And it is immigration attorneys like myself that we see a particular provision and a particular law that's unfair, so we'll appeal it up till we get to a federal level, and then we'll argue the constitutionality of that provision, whether, you know, it shouldn't be retroactively applied, whether it violates due process, equal protection, whatever it is. And hopefully we will get a ruling saying, yes, this particular provision does violate due process and therefore should be not used in this particular context. And so in that regard, in effect, if we keep fighting and fighting against these unfair laws through the appellate process, it will only help the immigrants and help the persons who are appealing. Okay, more on the coming videos.